Quitting and seeking EI, employment insurance benefits. The importance of advanced legal consultation. When you quit your job in Canada and wish to obtain EI, employment insurance benefits, you will be expected to prepare and file Form INS 5109, Quit, Voluntary Separation from Employment, with Employment and Social Development Canada. Form INS 5109 has 6 central sections. 1. General questions. 2. Prospective new employment. 3. Health reasons. 4. Illness and family. 5. Relocation. And 6. Early retirement. For purposes of this video, we will be looking at situations where these last 5 scenarios do not exist. An employee is quitting without a new job having been secured, no medical or relocation issue necessitating an end to one's employment, or early retirement circumstances. The General Questions section of Form INS 5109 seeks relevant employer contact information and employment end date, and proceeds to ask a mere 5 questions, providing a limited space to answer those questions. As will become clear, consideration of these questions in advance of quitting one's job can be pivotal to receiving regular employment insurance benefits, with advanced legal consultation being particularly beneficial, given what should be asked of one's employer in advance of quitting one's job, since there are highly technical aspects that can come into play with both one's employer and the government authorities managing employment insurance benefits. The first general question, quote, what was your reason for quitting your employment? If more than one reason is applicable, please list your reasons in order of priority, end quote. Now, when it comes to reasons for quitting your employment, to qualify for EI, employment insurance benefits, you must have just cause for quitting your employment, with there being 14 legislatively prescribed areas justifying for-cause job departures, set out in Section 29 sub C of the Employment Insurance Act, being 1. Sexual or other harassment. 2. Obligation to accompany a spouse, common law partner, or dependent child to another residence. 3. Discrimination on a prohibited ground of discrimination within the meaning of the Canadian Human Rights Act. 4. Working conditions that constitute a danger to health or safety. 5. Obligation to care for a child or a member of the immediate family. 6. Reasonable assurance of another employment in the immediate future. 7. Significant modification of terms and conditions respecting wages or salary. 7. Excessive overtime work or refusal to pay for overtime work. 9. Significant changes in work duties. 10. Antagonism with a supervisor if the claimant is not primarily responsible for the antagonism. 11. Practices of an employer that are contrary to law. 12. Discrimination with regard to employment because of membership in an association, organization, or union of workers. 13. Undue pressure by an employer on the claimant to leave their employment. And 14. Any other reasonable circumstances that are prescribed. Now, some of these just cause circumstances are relatively straightforward and unambiguous, such as sexual harassment and racial discrimination, while others are more detail-oriented and subject to reasonable alternative considerations, such as changes in work duties and excess overtime work. However, there are others that are actually more prevalent, yet require a lawyer such as ourselves to properly identify and explain, given their highly technical and legal nature. One then proceeds to the actions that were taken by the employee to address these reasons, where it was reasonable in the circumstances to engage with the employer and seek to correct the situation. We see this in the second and third questions. Quote, did you take action to rectify the situation problem that prompted you to quit your employment? If yes, please specify. If no, please give your reasons in detail, end quote. And quote, did you discuss the situation problem with your employer prior to quitting your employment? If yes, what was the result of this discussion? If no, why did you quit prior to discussing your situation problem? Please explain your reasons in detail, end quote. Here you need to be careful in your response to the government and properly craft your response, such that engaging a knowledgeable lawyer and having an appropriate plan of action is essential. Given that many employees could have asked their former employer some very effective questions that would have justified quitting their job and being entitled to both employment insurance benefits and additional payments from their former employer. Now, if you've quit your job in advance of consulting a lawyer, this shouldn't stop you from contacting a knowledgeable lawyer, since the reasons are all too often still there. It simply means that the lawyer-directed paper trail has not been created. The section has two further questions about pursuing further employment. The first in relation to job searches prior to quitting, and the second in relation to job search efforts after one quits their job. Given that it is an obligation to seek replacement employment of a comparable level to be entitled to regular employment insurance benefits, these questions need to be answered in a manner consistent with the government's expectation that, quote, as an employment insurance EI claimant, you have always been responsible for conducting reasonable job searches, documenting your job search activities, and accepting any offer of suitable employment while receiving EI regular benefits, end quote. The critical aspects are the reasonableness of one's job search and the suitability of the new employment, which are outside of the scope of this video. Although Form INS 5109 may appear relatively straightforward, the implications of not taking appropriate advanced action and completing it with sufficient legal consideration can have enormous financial consequences for an employee quitting their employment. As such, engaging with a knowledgeable lawyer can be highly advantageous where one's employment circumstances justify quitting for cause, with the conditions for just cause quitting being far more prevalent than most Canadian employees would honestly imagine. Nevertheless, the importance of early action plays a critical role in seeking regular employment insurance benefits, and other legal avenues may well be available for those employees who have quit their job yet are denied employment insurance. For a free confidential consultation, contact our law firm with the contact information being found at our website and in this video. Thank you.